I'm always amazed that anybody wants to come out on a nice evening like tonight is, here in Southern Connecticut, to listen to a lawyer talk about anything, to be honest with you, and especially a topic like fraud. Let's face it, this is not one of the fun ones. Okay, that I do. I'd much rather be talking about how to sell or, the marketing and all the fun stuff that I do. By the way, just a little free plug. I have a YouTube channel, by the way. This program's being videoed and it's going to be part of my YouTube channel. If you go to youtube.com, search for Cliff Enico, you'll see I got about 35 programs, a lot of the SCORE programs that I've been doing now for over 25 years. It's hard to believe I've been doing them for this long. Ruth knows, exactly. You've seen every one, I think, right? You've been there for the beginning. Just about, I know you have. But there are two things, when you're running a business of any kind, a small business of any kind, there are two things that really get to you and that really burn your breakfast, probably worse than anything else. One is when clients don't pay you, right? And that's my Dealing with Deadbeats program that I've been doing for SCORE now for many years. But the second thing is when you realize that you've been lied to by somebody. That's when the whole topic of fraud comes in. Okay. By the way, I do have a couple of copies of my books, unfortunately not with me, but I will give a free copy of my book to anyone who can tell me where I got the title for my program. Don't shout it out, but at the end of the program, if you know where I got the title to my program, I'll mail you a free copy of the crowdfunding book. It's really cool. Now you know I'm a lawyer. Right? We always tell you what we're not going to do before we do anything. The most important one here is the second one here, which is, I'm sure you guys have questions, and I'll try to do what I can to answer them at the end of the program, but nothing that I say here today should be construed as legal advice. There's a very big difference between saying, this is what the law says, and this is what you should do. Okay, for me to do the latter, I kind of have to get to know you a little bit, charge you some money and do all that kind of stuff. It's honest, this is how I make my living, But also too, if any of you guys, listen to something, oh yeah, this is a good idea, I really should do that, and you go off and you do it and it doesn't work, and you go bankrupt and your spouse divorces you, your dog pees in your leg, you end up living in a diaper box under the Brooklyn Bridge. This is not legal advice that you're meant to rely on. Okay, this is just some information to help you deal with your attorneys, your accountants, your advisors in a more intelligent and educated way. So let's get to the right heart of it. What is fraud? Okay, here are some legal definitions. It's an intentional act. I boldface that word because this is the essence of fraud. Fraud, not every lie is fraud. In order for something to be fraud, I have to intend to lie. I have to know that I am lying. Okay? Not every lie is fraud. An intentional act meant to induce another person to part with something of value or surrender a legal right. Okay? The core here is deception. Here, I have to intend to deceive you. Okay? If I do something, if I say something and you take it the wrong way and it ends up not working out for you, that's not necessarily fraud. As long as I didn't intend to deceive you, that is not necessarily fraud. Fraud is what we lawyers call an intentional tort. I've never liked the word tort, by the way. To me, I think of chocolate cake when I think of tort. I just don't like the word. I like the English word. Our English friends have a much better word for this. They call these things trespasses. And I like that word just so much better because it gets the point across. A trespass, a tort, is a situation where someone has invaded your space in some way. The classic trespass, you're crossing over somebody's lawn to get to the bus in the morning, that kind of thing. That's the classic example of trespass. I'm walking down the street, I punch you in the nose for no good reason. I have invaded your personal space. Think of torts as trespasses, and they're a lot easier to understand. In this case, I'm invading your space to try to take something from you by deceit, is what I'm doing. I'm reaching into your pocketbook and basically picking your pocket, is what I'm doing here. It's a deliberate misrepresentation or concealment of information. We'll talk about, there's active fraud and there's passive fraud, and we'll talk about this in a minute, in order to deceive or mislead. There are many different forms. In fact, a lot of statutes define fraud differently. There's over 100 fraud statutes in the Federal Register alone, at the federal government level alone. There are over 100 statutes that define fraud, and they all define them slightly differently. They all define them slightly differently. So when you're talking about fraud, you may be talking healthcare fraud and software privacy are two very different things, as is software piracy versus internet fraud. These are just some of the examples of fraud, but they all have one thing in common. They all have deception and sometimes intent, okay? Here are some examples of fraud. Any dishonest or fraudulent act. Fraud is fraud, right? Forgery or alteration of a check. Misappropriation of assets. I take stuff that you've left me in trust and I do something bad with it. Deliberate impropriety in the handling or reporting of money or finances. Embezzlement can be fraud. Wrongfully using influence in a business transaction, bribery, kickbacks, bid rigging, profiteering as a result of insider information is also considered to be fraud in certain circumstances. Again, if there is an intent to deceive, there's probably fraud. Here are some things, though, that fraud isn't. Fraud isn't everything. Abuse is different than fraud. Abuse is abuse of authority, abuse of trust. This is behavior that is deficient or improper when compared with behavior that a prudent person would consider reasonable and necessary business practice given the facts and circumstances. So if I'm engaging in some acts that exceed my authority to do something, well, you might be able to take action against me for that, but it's not fraud. I'm not deceiving anybody. I'm exceeding my authority, and I'm holding myself out as having authority that I don't have. That's a little different than lying or deceit. Puffery, overblown claims based on exaggerations, opinions, or superlatives that no reasonable person would take seriously. Believe it or not, that comes from the Federal Truth in Advertising Act, that definition. So if I come up here and I say, now, ladies and gentlemen, this is the best program on fraud that you are ever going to hear. I am the best expert on fraud that has ever existed, and no other program in the history of the world on fraud has ever been as good as this one. I'm engaging in puffery, right? You know darn well it's not true. You know, and I don't expect you to believe it either. I'm just saying great things about myself because I got a huge ego, like some other people we all know, right? You know, that's what I'm doing here. That's not fraud. Puffery is not fraud. To say I am the greatest isn't puffery. It isn't fraud at all. It's just puffery. It's what you do to try to sell something. You know, a little exaggeration in the interest of selling something is okay. When you cross a certain line, though, then it becomes fraud. Then it becomes false or misleading advertising, which is a form of fraud. Opinions are not fraud. I think that or I believe that. There cannot be fraud. Fraud, at the end of the day, has to do with misrepresenting a fact. That is what fraud is. An opinion, you are entitled by the First Amendment to the Constitution to have whatever opinions you want to have. If you say, I think the moon is made of green cheese, well, you're obviously wrong about that, but that's not fraud. You're not deceiving anybody. It's just what you think about the world. You know, so for example, I mean, Cliff Enico was one of the worst attorneys who's ever lived. No one should ever use him. Well, if someone's going around saying that, I don't like that. If I ever catch that person in a dark alley, you know, there are, as we say in law, there are remedies and there are remedies. But I can't really do a thing about that. You're entitled to your opinion. If I did something for you and you didn't like the work that I did, you're entitled to your opinion. You're entitled to go up on Yelp and say all kinds, Yelp.com, and say all kinds of bad things about me. But if you're going around saying, Cliff Enico, don't ever work with that guy. He's been sued 36 times for malpractice in the last year. That's a different order of magnitude. There, well, it's actually defamation too. It's libel too, or slander. But there you are saying something that is absolutely wrong about me. I have never, knock on wood, been sued once in my 36 years of practicing law. All right, may that always continue. You know, you are saying this deliberately to hurt me, to harm my reputation, to take business out of my pocket. That could be a form of fraud. It's also libel and slander, you're saying. An opinion can never be actionable as long as you make it clear to the person you're talking to that it's an opinion. Is this too metaphysical a little bit? I hope not. I'm trying to show you by contrast what it is and what it isn't. Negligence or recklessness. Acts or omissions that breach a duty of care, but without the intent to harm. The doctor that leaves the sponge in your stomach at the end of the surgery didn't intend to do that. Believe me, he wanted to avoid that as much as you do. He didn't want to hurt you, right? But let's face it, this is why they call them accidents, right? The person who rear-ends you at the toll booth did not intend to do that. they were texting on their phone, or they weren't looking where they should have been looking. And you can sue for that, but not for fraud. This is not fraud. It wasn't an intentional act or omission that they did. And then last but not least, a mistake. Someone doesn't know or is ignorant of the truth. If I'm selling you something on eBay that I think is 100% genuine, but it turns out it isn't, okay, that may be fraud if I knew that this thing wasn't what I said it was. But if I really believe in good faith that it was 100% original, I just don't know my merchandise, eBay sellers get into this all the time, okay? You know, the minute somebody buys something on eBay and it turns out not to be 100% genuine, they cry fraud. A lot of the times, though, it isn't fraud. It's just that the seller didn't know his merchandise, that's all. Somebody selling stuff out of his grandma's attic, he had no idea whether this was a 1910 thing or a 1960 thing. These people get into that kind of hassle all the time. It's not fraud. It may be other things. You can certainly get your money back on eBay if that happens, but it's not fraud. Here's one example of a fraud definition. I took the SEC one because this is one that I happen to live with a lot. It's SEC Rule 10b-5. This is the definition of securities fraud in the federal securities laws. It shall be unlawful for any person, directly or indirectly, by the use of any means of instrumentality, yada, yada, A, to employ any device, scheme, or artifice to defraud. B, to make any untrue statement of a material fact. Okay, now, look at B very carefully. To make any untrue statement of a material fact, or to omit to state a material fact necessary in order to make the statements made in the light of the circumstances under which they were made not misleading. We call these two things active fraud and passive fraud. Active fraud is an out-and-out lie. I say something is yes when it's no. I say something is true when it's false. I say something is X when it's really not X. That is active fraud. Passive fraud is where I only tell you half the story. I tell you a statement that's true in itself, but I leave certain things out so that you make the leap of faith to complete the thought and end up getting into trouble and losing money because you jumped over the cliff. It's like those old Roadrunner cartoons. Remember where the Roadrunner is being chased by Wile E. Coyote and they go right up to the edge of the cliff? Roadrunner stops, Wile E. Coyote keeps going over the cliff. That's what this second part, passive fraud, is, where I say enough to make you think, oh, he means X, Y, and Z, okay? But you're the one who made that conclusion. I didn't actually say it. That's passive fraud. Politicians, by the way, are expert at passive fraud. You know, they say something and you really think they said something, but they really didn't say. When you go back and you look at a literal transcript of what they said, they didn't really say what you thought they said. That's an example of telling half-truths, and we'll talk about those in another minute. To engage in any act, practice, or course of business operates or would operate as a fraud or deceit upon any person. This is just one example of a statute that defines fraud. Again, there are over 100 statutes at the federal level alone in this country that define fraud in some form or another, and they're all different. Can you commit fraud by accident? I mean, I said, in order to sue somebody for fraud, there has to be intent to deceive. Someone who accidentally says something that's not true is not guilty of fraud, okay? That isn't 100% true. Connecticut is one of a few states that have adopted the concept of negligent misrepresentation. Negligent misrepresentation doesn't have to do with intent. It has to do with what you know. So if you're trying to make a case in Connecticut on negligent misrepresentation, or in the dozen other states that have this, you have to show that the person made a misrepresentation of fact and that they knew or should have known that it was false. Even if they did not have an intent to deceive you, if they knew or should have known that the statement was false and you relied on it and you lost money because of it, you can sue for negligent misrepresentation. Negligent misrepresentation kind of falls halfway between fraud and breach of contract in a certain way. It kind of falls in sort of a little gray area there where I say something, I'm not really intending to deceive you, but I should have known that the statement was false. You relied on what I said and you lost something because of it. You got injured in some way. This is how the law gives you redress against me. And there's the citation. It's a 2009 case in Connecticut, the Connecticut Supreme Court that created this. Okay. Can you commit fraud by telling half-truths? The answer is yes. Okay, to tell the whole story. So, for example, years ago, I represented a nonprofit that relied a lot on corporate sponsorships and corporate donors, right? Well, one year, their biggest donor cut their donation in half. They did renew their commitment for another year, but they cut the donation in half. The nonprofit directors sent me a press release saying in glowing terms, XYZ Corporation renews its commitment to our nonprofit organization. Didn't say anything, though, about the donation being cut in half. That's an example of a half-truth. Other donors looking, or potential donors looking at this release, they'll say, oh, XYZ Corporation's in, they're putting a ton of, they renewed their commitment, oh, they must really love these guys. That could be fraud. And I told the directors that. I said, you are not sending this release out the way it is. You have to disclose the whole. There are ways that a good PR person can word this so that, you're telling the truth, but you're still not hurting yourself. But you got to disclose the whole story. You can't just say that they renewed their commitment without telling people that it's only half of what it was last year. Okay? That's a classic example of telling a half-truth. Mere silence, however, cannot be fraud. It is not considered fraud. So if you ask somebody a question and they just don't answer, that in itself cannot be fraud, unless there are some exceptions. Full disclosure is required by statute. For example, here in Connecticut, most of you know, if you are selling a house here in Connecticut, you must disclose to your buyer that if there was any termite damage. There's actually a statute, there's actually a form that your realtor prepares where you make that disclosure. And if you fail to fill out that form, and there was termite damage on the property at some point, you have committed fraud, even though you did not say specifically there was no termite damage. That's an example. Sometimes the law requires that you make full disclosure. And if that's the case, silence will constitute fraud. Where parties stand in a fiduciary relationship, if I'm in a special position of trust with you, and you ask me something and I blow it off, that could be considered fraud. If you suffer damage because of it. And then last but not least, where silence is equivalent to speech. There are situations in which silence, when you don't answer at all, you in fact have answered the question. There's a famous old case, it dates back to the 1600s. The case involved a guy who was buying a horse. The horse had all kinds of problems. The seller didn't want to actually come out and make too many claims for the horse because he knew he had a bad horse. He had a lemon on his hands, basically. This is one of the first lemon law cases, from the 1600s. It involved horses rather than cars. But what the buyer did, he said, if you do not deny, I will consider the horse sound. And the seller did not say anything in response to that. And a judge said that that silence, because of the way he phrased that question, was the equivalent of speech. It's kind of cool, kind of a cool case. I like going back into the old stuff sometimes. Life was a lot simpler back then. Okay, let's shift gears. So that's the legal theory of fraud. Now let's talk about specific kinds of fraud and what you do about these things. Okay, fraud in the workplace, obviously a big issue for most. If you are an employer, you are going to have to deal at some point with employee fraud, okay? Here are some of the things you want to be on the lookout for. You want to be on the lookout for unauthorized transactions, right? Things that did not go through the proper channels. Unexplained pricing exceptions. An employee is giving people all kinds of discounts and it's not consistent with your company policy. Excessive payments to vendors. One of the toughest things you got to watch out for, and especially if you're in a consulting type of business, your employees sometimes get very close to your clients and to your vendors, and sometimes they will collude with each other to steal money from you. I have seen, within the last year, I think I've seen 4 or 5 situations of that in my practice, where one of somebody's employees, or in some cases was a partner, got so close to a particular client that they started falsifying invoices and stuff, and the excess was going into this guy's bank account. That can happen. Look out for collusion. Very often fraud is not just one person. It's a conspiracy of 2 or more people. And you have to watch out for that. Significant increases in expenditures. Hey Joe, I know we use a lot of paper clips in this business, but why are we spending $5,000 a month on paper clips? Nobody spends $5,000 a month on paper clips. Not even IBM spends $5,000 on paper clips. What's going on here? You're probably being ripped off. Large transactions involving petty cash. The petty cash, you keep replenishing the petty cash account every 2 days. Something's wrong with that. Inability to trace invoices and payments with available records. The records don't match up. And big thing, never, ever, ever give an employee power to both process and approve expenses. Those 2 functions have to be in 2 different bodies. If you only have one employee, then you're the other guy. You're the person who has to authorize the expense. They can process the check, they can write the check, they can sign it if they have signing authority with the bank, but you're the one who has to approve that transaction. Never ever let an employee, even your closest friend, your spouse, have that kind of authority, because it's too big a temptation, quite frankly. Okay? Continuing here, some other examples that you might think that fraud might be going on. Missing or altered documents, somebody's forging invoices, doing stuff like that. Excessive voided documents or transactions. Half the checks in the checkbook have been voided. That looks weird. Either somebody just doesn't know how to write the English language, or, we all do it every once in a while. The numbers and the words don't match up sometimes because you're not thinking about what you're doing. But if it's happening, more than a few times on each check cycle, it's probably a problem. Those voided checks are not voided. They were processed, and then the guy wrote void on top of it. Transactions with inappropriate authorizations, excessive complaints from customers or other employees, unusual billing addresses or arrangements, payments based on photocopied invoices or fabricated invoices, vendor payments. I actually have seen clients, believe it or not, whose bookkeepers did not catch this. The vendors, the vendor payments, all the vendors were right, but the payments were going to a residential address. Like IBM, 123 Susan Lane, and wherever. You can't do that. Okay, the key here to prevent fraud, if you have at least one employee, you need internal controls. There's the answer. You need internal controls, checks and balances to make sure that no one employee has such control over something that fraud can happen. Don't get me wrong, most employees are good people. They don't do stuff like this. But let's face it, we've all known, most of us have had a situation where we got in a little bit over our head financially, and a lot of people these days, especially since the recession, are in that situation. Even good people can get tempted if you give them the power to screw up. Even good people can fall. What will happen is they'll start saying, well, I'm only going to do this once, but as soon as I get my next paycheck, I'll deposit the money, I'll clean up the mess, no one will ever know. And then 2 weeks later, they have to do it again and again and again. And before you know it, they've taken $20,000, $30,000, $40,000 out of your business. And with the best of intentions, they intend to pay it back. That's how they're rationalizing it. They're not intending to commit embezzlement or fraud, but they are. You could put them in jail for doing stuff like that. If they've been stealing money behind your back, even if they intend to put it back, which they probably do, that is still embezzlement, that is still fraud. Watch out for employees who are living beyond their means, okay? If you are a consultant and you have a part-time employee who's driving a Lamborghini, first of all, that person should be an investor, not an employee, okay, if it's legitimate, but there could be something else going on there. People who have a history of not being able to manage money, be very careful when an employee has had a prior bankruptcy, by the way, especially if they're in a financial position. This sounds so obvious, but you'd be surprised how people don't think when they do background checks. They look at the criminal stuff. Yeah, they look to make sure they haven't been in prison, whatever, but they don't look at bankruptcies sometimes, and that can be a more telling indicator of whether someone can manage money or not. Here's a big one. Whenever you have an employee that refuses to take vacations, you offer 2 weeks a year, but they continue. Don't get me wrong. Everybody gets busy. Sometimes we don't use all the vacation time we're entitled to. But if that becomes a chronic issue, okay, that could be a sign that employee is playing around with you. Why? Why are they refusing to take vacations? Because they don't want anybody looking at what they've been doing. Somebody else is going to have to look at that stuff, and they're going to say, hey, wait a minute, what's Cliff doing here? Right? That's why they don't want to take vacations. That's a red flag. Are dissatisfied with work, have expensive habits, have close relationships with vendors or customers. Watch out for that. A lot of fraud in companies happens by collusion between a hungry inside employee and an outside vendor that wants a discount. Put that combination together, and there's a lot of room for games playing. Have outside business interests that are closely related to their employment. Now, we all know that non-competes are not always enforceable. We can talk about that, but this is one of the reasons why you want to have one of those. Because if they're doing something something on the outside that's quasi-competitive with what you're doing, that's going to be a real incentive for those people to try to steal customers, steal clients, do whatever, and go down the fraud path. Shifting gears now, let's talk about online scams and frauds. Okay, to me, I don't know, see, maybe because I'm a lawyer, I think most of these things are so blatantly obvious. I'm amazed that people get taken in by them. Whoever does those Nigerian, scam things, good morning, dearest darling, beloved one. The minute you see that, nobody calls their attorney that, right? Even if it's legitimate within the culture of whoever's sending the message, nobody calls their attorney that, right? So right off the bat, it's a fraud, right? But who gets taken in by that? Why are they still doing them? They wouldn't be doing them if people weren't falling for them. So you got to figure somewhere out there's someone who actually believes that a prince in Nigeria, has $130 million in an account just waiting for you. I just don't. To me, I don't get these things. I don't see how people. But again, I'm a lawyer. I'm probably overly cynical. Do they require you to pay money up front? That's an almost certain sign of a scam, unless, of course, if it's an attorney doing it, we call that a retainer. I have to say that. I always have to get a little money up front. See, I'm contradicting myself. If you go and listen to my Dealing with Deadbeats video, one of my points is you always should get some money up front from the customer, get them used to paying. So here I am contradicting my own video, but I'm not really contradicting it. We call it a retainer, and by the way, in my retainer letter, I always say, what makes it different is that it's not non-refundable. I always have in my retainer letter a clause that says, if you terminate me for any reason or we part company, you get back whatever I haven't used. That's the difference between a non-refundable upfront deposit and a retainer. You do get back whatever I don't use if we terminate the relationship halfway in. Are their promises too good to be true? Duh. Okay, remember McGruff the crime dog? If it's too good to be true, it probably is. There you go. What's in it for them? If this is a purely altruistic plea, I'm going to do this because I just think you are all great people and I want to share my knowledge, my gift with all of humanity. Okay? There's only two ways you can look at that. It's either a fraud or it's from a millennial. Millennials really believe that people are altruistic and that they will do things solely for the benefit of mankind. I attribute that to their youth, by the way. If there are millennials listening to this video, please do not be offended. I'm generalizing, yes, but I'm 62 years old. I can do it. It's okay. I'm circling the drain anyway, so I don't give a damn. But it's seriously true. As you grow older, you will realize not everybody does things for altruistic reasons. If I found a secret to the stock market, if I found a formula by which you always can beat the stock market, you can always get your money in at the right time and out at the right time, it's an algorithm or something like that, why would I ever share that with the rest of humanity? That's insane. That's a trade secret. I want to keep that close to the vest. I don't want the world knowing about that. Why would I gratuitously share this with the rest of the world? Seriously, people don't do that. If there is something in for them, then it's less likely to be a fraud. It might still be a fraud, but it's less likely to be a fraud. If this is an altruistic plea, I've just been doing this because I want to share my knowledge with the world and I want you all to become millionaires because of this new formula that I've developed. That's baloney. That's a fraud. They're trying to get your money some way. Are they dependent on your success for their well-being? Okay, this is a great thing. Look at their program. Look at the scam and ask yourself, do they make money only if I make money? If that's the case, then it's probably less likely to be a fraud. There might be some scamming going on, but it's much less likely to be a fraud. If they make money regardless of whether you make money or not, okay, well, then it's either a fraud or maybe a franchise. Anyway, are they dependent on you? Says, are you under time pressure to respond? Offer only open for the next 3 hours. Call our representatives, right? That's an example. Are you being pushed into making a mistake? Are there misspelled words and poor grammar? Okay, forgive me, I'm a lawyer, okay? Lawyers are the people who always had 100 on their spelling tests in grade school. I never had less than 100 on a spelling test, which probably explains why I'm a lawyer. If I have a copy of War and Peace, 2,000 pages, and there is one typo in there, I will find it, okay? So when I see, emails with, misspelled words and faulty grammar, I know it's a scam, especially if it's from the government. Let me tell you something. The IRS has the best spell checkers in the world. There is never a typo in a bona fide IRS email. Here's my test. Whenever you get an email from somebody and you're not really sure if it's a scam or not, read the text out loud in the privacy of your room. If you sound like Boris Badenov, remember Boris Badenov from the Rocky and Bullwinkle? You know, he's looking moose and squirrel. If you sound like that, it's probably a scam. This is somebody in some lower Slobovia somewhere that has come up with this, and this is how they think we speak English. Okay, seriously, that is one of the surest ways to spot a problem. Do they require payment by MoneyGram or Western Union? Watch out for that. Any email that solicits money via these means are almost always scams. Why? Because these transactions are like cash. They cannot be traced. And that's why fraudsters almost always, when they want payment by Western Union or MoneyGram or one of the electronic money wiring services. If you see that, it's almost certainly a fraud. Do they require sensitive information via email, like your social security number? Never give your social security number via email. It's that simple. First of all, for identity theft reasons, that should be obvious. But also, too, once you put that in an email, that stuff can be forwarded to anybody on planet Earth with a reply to all. Even if the company's relatively honest, they could make that mistake, and now your stuff's public information. Other information you should never put, your bank's ABA number and your account number. Don't ever put the two of those things together. Whenever a client wants to wire me money, okay, I always separate the two things. I'll give him the ABA routing number via an email, but I will always call and give the account number verbally over the phone to their people or whatever. Why? Because if someone has access to those two pieces of information, they can withdraw the entire balance in your checking account and you will never know about it. With that information, that is all somebody, at least domestically. Internationally, they also need something called a SWIFT code if it's overseas. But if it's if the fraudster is located here in the United States and they have your ABA routing number and your account number, they can wipe you out. So never put those two pieces of information in an email or in the same place where, and even if you're faxing something, I refuse to put them in a fax either, because some low-level employee, the person who picks the fax up from the machine and brings it to the person, could make a note of that, and his sister-in-law is a computer fraudster and can wipe me out. You don't know who these people know, all right? Audit scams. The government never, ever, ever initiates proceedings by phone or email. If you ever get a phone or an email from someone saying, we're from the IRS, you're being audited, we picked your tax return for a random audit, that is a fraud. Do not go further. The government is required to do everything in writing. If you're being audited, you will get a written notice from the IRS. And sometimes they're bogus too. But they never, ever do business via email or phone. They never do that. They will never, at least not the initial contact. They may say, call our office to schedule a phone audit or a phone interview. That's okay. But they will never initiate the process with a phone call or an email. If you ever get an email like that, that's a fraud. Last but not least, lawyer scam. Someone says, I'm a lawyer, right? And I got all this money from an estate. You don't know it, but you're a beneficiary, all that kind of stuff. Here's a great trick. Ask them for their juris number. Every lawyer in the United States has a social security number. It's called a juris number, and no two are the same. Every attorney in the United States has a juris number. If the person cannot remember their juris number when you ask for it, that is a fraud. In Connecticut, there's 6 digits. I don't mind telling you, mine is 402179. You can look me up on the Connecticut Bar Association. It's right up there. This is not a secret thing. It's just a way of identifying that you are, in fact, dealing with this particular lawyer. Every lawyer has one. If they say, well, what's a juris number, or I don't have one, it's a fraud. It's absolutely a fraud. Okay, so now let's shift the gear around. So far we've been talking, how to protect yourself from fraud, but now let's say that someone says you've committed fraud. How do you protect yourself against that, okay? Plaintiffs' attorneys especially often try to recast negligence cases as fraud. You know, when someone commits malpractice or negligence, they try to add a fraud claim in there. They almost do. And the reason is because the case is much less likely to be dismissed if there's a fraud claim. You know, when a judge sees a fraud claim, they're much more likely to let that case go to a jury or to a trier of fact. And that's why a lot of plaintiffs' attorneys throw a fraud claim. Even if they don't think there's any basis for it, they'll try to throw that in. Your goal here is to defeat a claim that you intended or knew that a statement is false. Remember what I said before? 99% of all fraud claims are based on intent or knowledge. Either you intended this to deceive, or in the case of negligent misrepresentation, you knew or should have known that the statement was false. If you can defeat either of those two claims, then that'll destroy the fraud claim. Okay, this is your goal. So how do you do it? Whenever you do a contract or a notice to someone on your website, your terms and conditions, disclaim all warranties. This is a knee-jerk response. You know, eBay sellers do this all the time. If you ever read their listings, I don't know nothing about this stuff. I'll be happy to answer your questions, but I'm not an expert. I do not know if this is a Generation 1 Beanie Baby or a Generation 2 Beanie Baby. I haven't a clue. I found this in my ex-wife's closet, the back of my ex-wife's closet, and I'm putting it up on eBay to make some beer money. That is a perfectly valid legal disclaimer. As long as you say, I don't know, I'm not making any warranties. If this turns out to be bogus, I don't know. Buyer beware. That is, and that should be in all your contracts, in all your web documents, everywhere. Sometimes the courts don't enforce them, but the one thing it will do for you is it will defeat a fraud claim. If the minute you say, I don't know whether this is true or not, you have defeated a fraud claim, because no one can say you knew that the statement was false. Okay? At the very least, the disclaimer will do that for you. Then, whenever you do make a warranty, sometimes you have to, okay, always put to the best of my knowledge and belief. Again, you're hedging your bets here. I have reason to believe this is true, but I'm not 100% certain. That's what that says. To my knowledge and belief. Sometimes the other side will want you to say, upon reasonable investigation. Talk to your lawyer about that one. Sometimes that's okay, sometimes it isn't. But always try to get, to the best of my knowledge and belief, all statements made in this document are true. Okay, be very careful about anyone who wants you to sign a document that says, under penalties of perjury. Be very careful. That language is loaded. That is deadly language. That means you are guaranteeing the accuracy of every word that appears in that document. And if one word is inaccurate, you're subject to criminal penalties. Never sign something where it says under penalties of perjury, unless, of course, it's a government document, and that's the language that they require. Clearly say that something is an opinion, not a statement of fact. If you're talking about certain politicians and alleging them that they're liars, whatever, always make it clear, well, I think that this person has never had an honest day in his or her life. You know, make it clear that you're saying an opinion. Don't say statements like, this person lies all the time, they lied about this, they lied about that, they lied about that, because those statements can get you into a lot of trouble. It could be fraud, it could also be defamation, libel. The line between fraud and defamation, libel and slander, is a very thin one, especially when you're making statements about other people. And then you may get sued. You may still get sued, by the way, but it won't be for fraud, it'll be for something else. And that's all I have to say. Fraud is really a simple topic, really. It all boils down to intent or knowledge, and whether or not you intended to deceive somebody or knew that the statement was false at the time that you made it. And if you think about it, it's a very difficult thing to prove in court. In order for me to prove that you committed fraud, I have to prove that you knew I have to show what was in your head. Right now, I don't know what's in any of your heads. With a couple of you, I can probably, I have a suspicion I do know. You're pretty easy reads. But I don't know any of you well enough to know what's in your head right now. So it's a very difficult claim to prove. Be very careful before you accuse someone else of fraud. By the way, talk to a lawyer before you make threats against anybody, but especially with a claim of fraud. It's very simple to say, you know, you idiot, you screwed up, you're a fraudster, you're a scamster, when it's not in fact true. And if you do say things like that, you may be opening yourself up to a defamation case, a libel or slander case. So that's fraud in a nutshell. Questions? Oh, unfair business practices. Okay. Unfair business practices in most states is a catch-all term for, we really don't like what you did, but it doesn't really fall within any of the other categories, so we're going to call it an unfair business practice. This area of the law comes out of what's called unfair competition. It sometimes involves fraud. So if you're making false statements about your competitors' products, for example, well, you know, kids are getting sick left and right because they're using lead paint in those things, that could be a fraud claim, but it doesn't have to be. It can simply mean taking an unfair advantage of a situation. The Connecticut Unfair Trade Practices statute is very typical of statutes in the country. Basically, the statute has two clauses. Clause number 1 says, from this day forward, unfair trade practices are illegal in the state of Connecticut. Then clause number 2 says, we will leave it to the courts of the state of Connecticut to determine exactly what an unfair trade practice is based on the facts and circumstances of individual cases. The statutes never define what an unfair trade practice is. Basically, it's a way for a judge to punish somebody if they really didn't like what you did, but they can't make it fit into one of the other boxes. Legally, they can call it an unfair trade practice. The cases in Connecticut, by the way, tend mostly to go in favor of the defense. It's very hard to prove an unfair trade practice case in Connecticut, but a lot of fraud cases also will have an unfair trade practices claim attached to them. Anybody, any other questions? In order to prove a case for fraud, you have to show not only that the statement was false, that's the easy part. Showing that I said something that was wrong is the easy part. The hard part is, did I intend it? Did I know that it was wrong at the time I said it? If in good faith I was just stupid and I didn't know any better, well, you might be able to sue me for something else if you relied on it to your detriment, if you suffered because you relied on that statement being true. But it's not fraud. Fraud involves intent. You have to show that I intended to do you some harm. I didn't like you, so that's why I told you, oh yeah, turn right, by the way. And those signs about the cliff up ahead, just ignore those. Those are from years ago. They fixed that problem years ago. No, seriously, there are cases like that, yeah. You get it. The line between fraud and defamation is a very thin one sometimes. The situation there, the situation is, you know, someone says to you, Cliffenico's been sued 36 times for malpractice, and you innocently, not knowing any better, repeat it to someone else. Are you guilty of defamation? And the answer is going to hinge on whether or not you intended to harm me by making the statement. You know, if you made the statement just, you know, because you wanted somebody not to hire me, you could be held liable for defamation, you know, because you did not make any effort whatsoever to investigate the truth of that statement. You can go online in 5 minutes and find out if a lawyer has been sued ever for malpractice. That's one of the easiest things in the world to find out. Whenever you're concerned about being sued for fraud, you want to make sure that the statement isn't intentional or made with knowledge. And anything you can do to disclaim that will probably work. The eBay, I use the eBay sellers because they tend to be very colorful in how they do this. But you know, even when I sell some stuff on eBay from time to time, I will say, I am not an expert in this merchandise. I'll show you all kinds of photos. There's a little mark there with 2 crossed swords. I have no idea what this means. I'm just looking to clean out my attic here, so bid accordingly. You know, I'm not taking returns or exchanges. You know, that's the way you deal with that. You know, no one, you know, I may have to give them their money back because of something else. There was a chip maybe that I didn't disclose or whatever, but I'm not going to be sued for fraud because of something like that. The word fraud gets thrown around very, very loosely. It's really a very narrow thing, and it's very, very hard to prove in a court of law. Okay, the question is, in a situation where there was fraud and there was collusion, say between an employee and a vendor or something like that, at what point does that rise to a level of a conspiracy? That is a very complicated area of the law. It's criminal law, basically. And it's one of the hardest things. If you ever take a criminal law course in law school, you spend half the semester on conspiracy because it is so hard to prove that people were acting in concert. You know, sometimes what happens is that the employee develops a friendship with somebody at the vendor and starts padding the invoices, but the employee of the vendor doesn't know what's going on because they're a low-level employee and they're not really doing, somebody else is doing the internal checking, so they don't know this is going on, that padding is taking place. That is not a fraud case. That would not be conspiracy either. If for a conspiracy to happen, the two have to be in cahoots and they have to know that they are in cahoots. Is what would have to happen. Criminal law almost always is intentional. There are very few crimes that are committed negligently. Okay, DUI is probably one of the few. You know, but the whole idea is that you're engaging in reckless behavior by driving under the influence. But most crimes, almost all crimes, we don't like the idea in a civilized society of putting people in jail because of accidents or mistakes. We don't like that as a civilized society. To put somebody in jail, to take away their freedom or possibly their life, in states that still have the death penalty, you want to know that that person knew what they were doing. They pulled that trigger and they knew exactly what they were doing, but they had the specific intent of killing that guy over there. That's what they had to do. So conspiracy is trickier. One of the hardest things to do, especially as an employer, if you find out that this is going on, you've got to think about it. You really got a difficult issue here. On the one hand, you got an employee that's ripping you off. On the other hand, you've got a key customer here who's involved. If you call the client, the customer, too much on the carpet, they may be so embarrassed that they stop doing business with you. Even if you win, you might lose a client. So, I know clients who over the years have tolerated a lot of monkey business, even years after they found out about it because they didn't want to alienate a key client. That can happen. There's the law, and then there's what you have to do to stay in business sometimes. Shame on you, though, for letting that happen. Okay? When you find out that this thing has been going on for years, it gets very, very difficult to solve the problem at that point. And that's why eternal vigilance is the price of running a business. It's an old Thomas Jefferson quote, eternal vigilance is the price of liberty. Eternal vigilance is also the price. The minute you see weird stuff going on in your books, you call in the relevant employees and you ask lots and lots of questions and find out what's going on here, because that's how these things get started. You said you had another one?
Yeah, actually, relationship.
Okay, the question is, can you get into a cooperative business relationship where there's fraud going on, but the defense would be, well, wait a minute, you've allowed this to go on for so many years that there really is no cause of action. The short answer to that is no, unless there was knowledge that it was going on for years and years. What would happen is, so for example, in the situation where an employee has a collusive relationship with a vendor, you find out about it, but because you don't want to alienate that vendor, they're a key supplier, they're the only supplier in the United States for the stuff that you need to do whatever it is you do, you decide to just shovel it under the carpet. At some point, you will not be able to sue to stop that. Someone else might. But you would lose that ability at some point. The technical term for it is laches, L-A-C-H-E-S. At some point, if you know that something is going on and you allow it to happen, you have lost your ability to pursue that case in court. When the opportunities become a bit better. That's the trick, but it has to rise to that level. Just because the thing has been going on for years doesn't mean anything. If you didn't know about it and you find out about it now, there are things you can do to take action there. What I would normally tell a client to do is start building a case against this employee. Get that employee out of there. Start giving him bad performance reviews and lead him down the road to termination. Get rid of him. Don't rub his face in it quite yet, but get rid of him. Once you get rid of him, the problem will stop. Him or her, the problem will stop. That's usually the advice that I give in a situation like that. It's tricky. The whole thing about relationships that go on for years and years. I have never seen a case yet, although there might be. Nobody knows what's in all the law books, but I've never seen a case where someone who's being sued for fraud, defendant saying, "Well, wait a minute, you created the environment where I could do this." That is not a valid. I've never seen a case like that where that has worked. Okay, sometimes they try to defend, especially in criminal cases, they do anything to avoid going to jail, but I've never seen a case like that succeed where you created an environment that was conducive to fraud. That may, if the government comes after you for that, they might get away with that, but the employee, the person who was committing the fraud, they're not going to get away with that argument. It's not going to happen. Anybody else? Okay, one more. The question is, what do you do with the customer who's, never mind, there's no collusion with an employee, but the customer is playing games, but because they're such an important customer, you kind of have to tolerate some of it and let them play some of the games sometimes. Some people would call that business, actually. I'm not so sure that I think there's an argument that that's the way a lot of things get done in this world. Let's face it, if a customer knows that they're the 800-pound gorilla and you can't live without them, they're going to play games of some kind or another. Maybe they'll be okay games, maybe they'll be nasty games, but they will. Most companies that I know would take advantage of that. You know, that's one of the reasons they always tell you in small business classes, never allow a single customer to account for more than 5% of your gross revenue each year, because the minute that happens, well, first of all, you become totally dependent on them, but also two, once they know that, then they might be inclined to start saying that's when your receivables start going out to 90, 120, 150 days. That's when that starts happening, because they know they can get away with that. I'll take one more from you, because I know you had a bunch of them. The question is, if there's a fraud case, they typically go to jury or sell. The short answer is it can go any one of a million different ways. When you do your contracts, one of the things I always try to put in my clients' contracts, something called a waiver of jury trial, where, you know, if God forbid somebody does want to sue me for something, they have to go before a judge, because judges are much less emotional than juries are. You know, you're much more likely to get a fair hearing before a judge than you are a jury. Juries act out of emotion. They're very, and forgive me, I've served on juries. I know what happens here. You know, if you're a large company and it's a little, you know, employee for her first job out of college, you know, and she didn't know what she was doing and all this, she's a very sympathetic person, and a jury might be tempted to rule her in her favor. So you want to try to get that clause in your clients all the time. Obviously, you try to settle these things as much as possible. Many people want to settle because they don't want to have that in their record. They were dismissed for fraud or embezzlement or something like that. I mean, that's the kiss of death in the job market. That's all you need is one. Here's a wonderful phrase, by the way. You'll see this in contracts sometimes. Moral turpitude. I love that phrase. You know, so in employment contracts, for example, you'll see a clause saying you're dismissed for cause if you commit a felony or misdemeanor involving moral turpitude. It's a wonderful old legal phrase, and what it means is that it's a crime or misdemeanor that kind of shows what kind of character you have. So getting a traffic ticket or a parking ticket does not involve moral turpitude. Even the most honest and genuine among us occasionally get a parking ticket, right? Fraud, embezzlement, those are crimes of moral turpitude. If you got caught embezzling money, that goes to your character, the kind of person you are. That's not the kind of thing that happens just accidentally or you kind of lost control. So, okay, with that in mind, guys, thank you very much. You've been a great audience. Thank you.